and to share some information with everybody today about advanced care planning and advanced directives. I'm Jamie Buller, and I am the Director of Advanced Care Planning with Community Hospice and Palliative Care in the Northeast and North Central region of the state. I'd like to talk initially about the difference between advanced directives and advanced care planning. Most people have heard of advanced directives. In fact, I always tell people in the community when I'm speaking to groups, whether it's a group of students at Jacksonville University or the University of North Florida, or a group of seniors at an independent living facility, that everyone should do some version of advanced care planning, and hopefully the end result is some type of an advanced directive. So it's important for people of all ages, beginning with the age of 18 as an adult, to do advanced care planning and have an advanced directive. And essentially that's the difference between the two. An advanced directive is a written document. It can be oral if someone is writing down what a person would like, but it usually provides direction on the kind of care we would want when we have a serious or sudden illness. And most importantly, it identifies the person we would want speaking on our behalf when we can't speak for ourselves. Advanced care planning is the process to getting to that point. It's the conversation and the communication that we have with family and with our health providers so that everyone understands our values and our beliefs. And what I like to say is everyone understands what matters most to us, what brings us joy, so that when someone has to step in and make decisions for us, it's easier for them to do that because they know what's important. These are the 6 advanced directives in the state, and I don't go into all of them today, just given time, but I will go into the first 4, the healthcare surrogate, the living will, the durable power of attorney, and the do not resuscitate order. You certainly can get more information on the pre-need guardian and organ donation, either by reaching out. I'm happy to answer questions. An attorney can certainly provide some detailed information about the pre-need guardian, and there is a nice review sheet on organ donation on the Honoring Choices Florida website if you'd like information about that. So starting with the healthcare surrogate, I simplified this definition by saying this person is my advocate. This is the person who would speak on my behalf and use what's called substituted judgment, meaning they would make decisions for me based on what I want, not what they want for me. And the only medical criteria that needs to be met in order for a healthcare surrogate to step in and make decisions is that I would have to lack mental capacity to do that for myself. There is an exception to that, and that is if in writing in my healthcare surrogate designation document, I indicate that I want my surrogate to make decisions for me while I have. But for the most part, people designate a surrogate to make decisions for them when they lack capacity. So when choosing a healthcare surrogate, the questions that you see on the slide are really what you should give thought to. Many times people tell me that their spouse is the most obvious person to be their healthcare surrogate, their decision maker. And in many cases, I'm sure that's true. I'll share with you, in my case, that's not true. My husband made it very clear about 40 years ago when I did my first advanced directive that he could not honor my wishes and he would make decisions for me based on what he wanted. So over the years, I've had to make changes to my surrogate because my father was initially my surrogate, and upon his death, I had to choose someone else. But I had a conversation with everyone I talked to make sure that they were willing to assume the responsibility. They were willing to make decisions based on what I wanted, not what they wanted for me. They also understood my values and my goals so that if they were ever asked to make decisions, they could make decisions with confidence and take some comfort in knowing that they would be making the right decision. In Florida, if we have not designated a decision maker, either through a healthcare surrogate or a durable power of attorney that specifically allows that person the authority to make healthcare decisions, then health providers have the authority to choose a decision maker, and that decision maker is called a proxy. And they have to choose the decision maker in the order of relationship that you see on the slides. So that first person that they would have to select would be a court-appointed guardian. Most of us don't have a guardian, so the next person would be a spouse. So if you think about my situation, if I did not have a surrogate designated, my husband would be asked to be my proxy decision maker. And that's exactly what I would not want. In the absence of a spouse, it's the majority of our adult children who are reasonably available, then parent, and then siblings. And it's the majority of siblings who are reasonably available. After that, it's any adult relative, and then any friend. And in particular, in a hospital, and especially in Northeast Florida, there are often patients who are being cared for who lack capacity to make decisions. And the hospital and medical providers have looked for someone in this order of relationship and have not found anyone. In that case, they can then call upon and name a licensed clinical social worker to be the proxy decision maker. And in the hospitals from Gainesville up through Fernandina Beach, so north central, northeast Florida, the hospitals have all entered into a collaborative agreement where the LCSWs at one hospital will act as proxy decision makers for patients who are considered unfriended at another hospital. The reason they did this is because the LCSW cannot be employed by the provider caring for the patient. So this allows all patients to have a decision maker. The dilemma becomes that licensed clinical social worker doesn't know that patient. And so there's no way that person would know what that patient's values or goals were. And so the law then allows the social worker to make decisions based on what they believe is in the patient's best interest versus using substituted judgment like everyone else in that order of relationship is called upon to do. Trying to keep an eye on time as well. The living will is the next advanced directive in Florida, and this is a witness document that you use to express the care we would want or not want if faced with a sudden or serious illness. Our living will is actually a document that gives direction about care, but it's only valid if we meet certain medical criteria. And this criteria is unlike the criteria for the surrogate. Remember, in order for a surrogate to step in and make decisions, I have to lack mental capacity, but I don't have to lack or have any other medical criteria or diagnosis. In the case of a living will, 2 physicians have to document in my chart, in my medical record, that I have a terminal condition an end-stage condition, or I'm in a persistent vegetative state, and I have to lack mental capacity. Because even with a terminal condition or an end-stage condition, I still have the authority and the right to make my own healthcare decisions. And it's not until I lack mental capacity that someone else would need to step in and do that for me. When I talk to groups in the community, I often have people tell me they've not done a living will because they're concerned they won't get care and treatment if they have a living will. And it's actually quite the opposite, because I tell them, remember, this medical criteria has to be present and verified by 2 physicians. We always, as long as we have mental capacity, have the right to make our own decisions. And a living will isn't just a document that says what we don't want. It should also express what kind of care we do want. And so we want to make sure that when we're completing a living will, it expresses both. A do not resuscitate order in the state of Florida is the only advance directive that has to be signed by a physician. First 2 that I talked about, the surrogate and the living will, have to be signed by the individual, and it has to be witnessed by 2 people. The people who are named as surrogates cannot witness, and 1 witness has to be someone other than a spouse relative. With the do not resuscitate order, it does not require a witness, but it requires the individual's signature or the legal decision maker if the individual lacks capacity, and the signature of the physician. The other primary difference with the do not resuscitate order is it has to be on a specific form, and that's a Department of Health form, and you see on the slide it's form number 1896. The interesting thing about the statute or the Florida law regarding this order is it has to be printed on yellow paper, and while copies are as valid as the original, copies always have to be on yellow paper. It serves as a medical order from your doctor, and so I believe that's just a provision in the statute to try to ensure that it's a valid document. This do not resuscitate order is an advance directive that is intended for someone who has a serious illness with a limited life expectancy. A durable power of attorney is a document that I do recommend individuals have drawn up by their lawyer. It gives very specific and detailed authority to a person who you select, with a lot of authority regarding financial affairs. So depending on what you put in the durable power of attorney determines what authority that person is provided. There is a list in Florida law about what should be in it, and the individual should initial yes or no by each provision in the document. Oftentimes there is 1 sentence in a durable power of attorney that would give that individual the authority to make healthcare decisions. So I caution people that if you do both a healthcare surrogate and a durable power of attorney, that you don't have that conflicting. Many people will choose 2 different people, to have someone act as their healthcare decision maker, the surrogate, and to have someone else act as a durable power of attorney. So you want to make sure, if you do that, that on that medical decision making authority provision that you initial no. If it's the same person, then of course it doesn't matter and you would initial yes for that. Another distinction between the durable power of attorney and the other two documents that I referred to earlier is that the durable power of attorney becomes effective immediately upon signing. So there's no provision that you have to lack capacity in order for your DPOA to have the authorities given to them in the document. So I also caution people to make sure that the person chosen as a durable power of attorney is someone who is trusted implicitly, because you're giving them a lot of authority financially. The screen you see now is just a side-by-side comparison, and I should have mentioned, of course, earlier, feel free to take photos of any of the slides you see that might be helpful. But this is a side-by-side comparison of the 4 documents that I've covered, referring to what each of them are used for if there is a particular document, and then the signature, witnessing, and notarization requirements. Of these 4 advanced directives, the durable power of attorney is the only one that requires a notary. I'm going to shift a bit and quickly go from advanced directives to advanced care planning. And, I mentioned early on that advanced care planning is more of a process. It's the process that we go through to get to the advanced directives that we choose to complete. And so key to that process is communication. And very often when talking to family or health providers, we're able to share prior experiences with loss in our lives, whether it's through our work history, maybe we worked in healthcare, or through our personal lives because we experienced the death of a loved one. But we're able to use those personal experiences to help identify and communicate what we'd want for ourselves. So that's part of the discussion when having a conversation with family and health providers. It's also important to talk about any cultural, spiritual, or religious beliefs and values that could influence our decisions and the kind of care we'd want for ourselves. And then finally, I group those bottom 2, the desired quality and the goals of care. I group those together. And it's easier for me to think about the kind of care I would want when I talk with my family, when I share with them what matters most to me and what brings me joy. And so that summarizes, I think, what a desired quality is and what my goals of care are. My family know that if I can't do those things that matter most to me and bring me joy, then they have an idea of what kind of decisions to make if they have to step in and be my decision maker. So think about it along those lines and share those or that concept with your family so that they understand what matters most to you. Sometimes it's hard for people to have this conversation. And I've had the conversation with my family for over 40 years because I actually started working in an acute care hospital many, many years ago. And I saw things in the hospital that were my experiences at the time. So I shared those experiences with family members to help them have a better understanding of what I'd want for myself. And so within my family, the conversation is normalized. And that's what you want to get to, is you want to normalize the conversation within your family so that you can bring it up casually and have a discussion and nobody is frightened or turned off by having the discussion. But if you talk about you and what matters most to you, and talk about your life. What does a good day look like? And talk about your choices. If something happened, this is what I'd want. Focus on those three issues, those three aspects of you and your care and your future to help your family come to an understanding about what you'd want when they have to step in and make decisions. And after you've done that, after you've had the conversation, you want to complete a document. It doesn't have to be this document. I'm sharing on the slide a picture of the Honoring Choices Florida document, which serves as a healthcare surrogate designation and a living will. Many people will use an attorney to get an estate package put together. Some people will go to the internet and just pull up Florida Living Will and download. You'd want to make sure that it has some required provisions in it to make sure that it would be valid with a health provider in the state. However, there are many forms and documents out there that would meet your needs. But complete a document. Once you've completed a document, you want to make sure to give copies to all your surrogates, your health providers, other family members. Talk and to everyone to make sure they understand your wishes. I tell people, whoever's at your bedside needs to know what you'd want, so there's no arguing, fighting, and disagreement towards the end of your life. You can certainly get more information from the honoringchoicesflorida.com website. There is a resource tab there with what we call fact sheets that give details about CPR, do not resuscitate, feeding tubes, ventilation, kidney dialysis, a lot of information. So feel free to go there and look for resource information. I am going to stop and come back in to see if there are any questions. We have 2 minutes. Happy to take any questions. I don't see any in the chat. Put the slide back with the comparison of documents. I sure can. Hopefully you can see that. Go back and see if there are any other questions. One minute, and I'm supposed to, what is the legal liability of the surrogate or designated decision maker if the wrong decision is made in hindsight? Well, Florida law actually indicates that if a decision is made in good faith, they are not held liable. So I can't quote where in statute, it's in 465. I can't tell you which, where in 465 it is, but it does not hold someone liable if they're making decisions in good faith. Could you please define the criteria to determine lack of mental capacity? That's an interesting one because someone can lack mental capacity in the morning, but in the afternoon, they have capacity and can make decisions. So a surrogate is called upon at any moment in time to make a decision. It does not mean they're called upon to make decisions indefinitely. Same with the durable power of attorney. and it's one physician's judgment